Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here today. I want to take just a moment before we call the first case and talk about a few matters. I know we have experienced practitioners here today, but we always feel better making sure everybody's on the same page. Our procedure is as follows. First of all, each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, proper procedure is to request that from the court after you've introduced yourself, but before you begin your argument. You may reserve up to 5 minutes of rebuttal time. Appellee gets no rebuttal time. When you come to the podium, you will see a monitor. We believe the monitor to be fairly straightforward. There are 3 lights on the monitor: green, yellow, and red. As long as the light's green, you're in good shape. Once it turns yellow, you're running out of time. And once it turns red, you're out of time, and we ask that you please respect those time constraints. Very important thing for everyone to understand. These arguments are being live streamed. So what that means for you and for us is whatever you say, once you've said it, it's out there for the whole world to hear. So please think about that before you begin your argument or you say something that perhaps you wish you hadn't. Your panel this morning consists of Judge Kenny Armstrong, who had a birthday yesterday and I missed, and so I apologize for that. But Judge Armstrong is from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before we get started?
No, Your Honor.
You may call the first case, please.
First South Financial Credit Union versus Collierville 385 Motors, LLC.
Whichever. Probably more efficient just to come on up.
Thank you. If it pleases the court, my name is Dennis Sadler, and I'm representing the appellant, Collierville 385 Motors, LLC.
Would you pull that back a little bit?
Yes, sir.
Please.
Is that better?
I think, we'll see anyway.
If I may, I'd like to reserve 1 minute of my time for rebuttal.
You are well, I admire you for that.
Thank you. Your Honor, the circuit court abused its discretion in denying Collierville 385's Motors motion to set aside the default judgment. The circuit court applied an incorrect legal standard in determining that Collierville's 385 had acted willfully, and it based its decision on a clearly erroneous assessment of the evidence and reached an illogical conclusion. In the alternative, we argue that the court erred in finding that First South had pled the allegations of fraud with sufficient particularity to allow it to award damages on the basis of fraud. And I won't rehash all the facts that are set out in the brief. The relevant facts that I'd like to bring the court's attention to: First South served the office manager of Collierville 385 Motors on March 7th of last year. Shortly thereafter, Collierville, the manager, resigned and then left without ever advising anyone at Collierville 385 that she had been served this complaint. And as a result, the deadline for filing an answer passed on April 8th. The CFO of Collierville Motors, 385, whose office is in Mississippi, made arrangements to come as soon as she could up to Collierville to go through and see what the situation at the business. Now, the circuit court did find that up to that point, the carelessness of Collierville 385 was not willful. In the record transcript, volume 2, page 31, sections 4 through 7, it says, Speaking of the CFO, the court said, we'll give her the benefit of the doubt. She didn't have knowledge maybe until April 14th because of the negligence of the employees. But once she noticed this, that's the trigger of willfulness for me. The CFO says that she found it actually on April 15th. 4 days later, on April the 19th, Circuit Court entered an order granting default judgment. On May 8th, an order of judgment was entered against Collierville 385. So for the period of April 15th, the date of her discovery, until May 8th, the date of the order of judgment, that's the relevant period for examining whether or not Collierville 385 acted willfully, a period of about 23 days. Now, about 2 weeks, or less than 2 weeks after the final judgment was entered, the motion to set aside the default was amply and timely filed. The Supreme Court of Tennessee, in regard to the legal standard for determining willfulness, has made it clear that determinations of whether failure to answer a complaint was due to excusable neglect, that willfulness is a threshold determination, first step. And the courts have consistently limited the definition of willful conduct to deliberate choices, flagrant, unexplained violations of procedural rules, whereas excusable neglect, on the other hand, can encompass omissions, carelessness, and even sloppiness.
So how do those facts play out here?
Your Honor, in this case, essentially, Collierville 385 has admitted to some sloppiness. Their office manager was served. We don't dispute that there was service. But then rather than letting anyone know with the corporation, she turns in a resignation and leaves. Once Collierville 385 found out, once the CFO discovered this, she immediately notified her insurer. And in reliance upon them to handle the matter, she reasonably believed that this was going to be taken care of. In fact, the insurance company did retain counsel, which was us, and upon our being retained and looking at this immediately, same day, we filed the motion to set aside the default. Again, it was within 2 weeks of the default final judgment being entered.
Well, I think you've got a real break from the trial court on the front end, because if my calculations are correct, Penny Stein was served on March 7th, 2024, and she left the employment of the defendant on April 5, 2024.
Yes, Your Honor.
She had that complaint for 29 days.
Yes, Your Honor.
She's the person who there's no question was supposed to be served and didn't do anything. But the trial court didn't find that to be willful, so that's well and good.
Yes, sir, and there have been situations that the courts have examined where the situation was even worse, where an adjuster was served, and it sat for months, and it was lost and not handled. Most of the cases that I've examined looking at these motions to set aside a default deal with, if not months, years. I believe it was the case in Keck where they even had a trial, and the court found that in looking at this, there was no willfulness. Sloppiness, absolutely. Neglect, yes, but no willful decision, no determination to try to gain some procedural or strategic advantage against the First South.
Is that the analysis, though? Isn't it simply, did this person intend to do what they did? And in this instance, your CFO was aware, what was it, April the 15th, I think, is the
Yes, Your
date?
Honor. Yes, Your Honor.
Is that, have I got the right person there?
Yes, Your
Vicki
Honor,
Smith.
April 15th.
And at best, she notified her insurance company.
Absolutely, and relied upon them as any business person would. She's a CFO, she's not an attorney. And despite that.
Is there any affidavit about reasonableness there? Is there an affidavit from the insurance company?
No, Your Honor, there's nothing from the insurance company as to what the delay on their part may have been. I can't speak to that. In fact, I think it would probably put me in a position of possibly being in a conflict if I start looking at what the insurance company did as opposed to what my client did. And I think that's the critical analysis is what did the client do and why did they do it? In Williams versus Baptist Hospital, the analysis for determining willfulness that the court laid out was to look at 4 factors and to weigh each of those factors. The risk of prejudice was one of them, the length of delay and the potential impact, the reasons why it was late, and the good or bad faith of the filer. In this case, it's our contention that the circuit court only looked at one of those and made a personal decision rather than a reasoned decision, a calculated decision weighing those factors to determine that that just wasn't good enough, that contacting your insurer once you found it just wasn't enough. That made it willful. In fact, that's what the circuit court said. That's the trigger for willfulness. In fact, it was erroneous for her to say that the CFO did nothing. She repeatedly said she did nothing. She even found it willful that the CFO didn't make an appearance in court or file an answer. She's just not capable of doing that, Your Honor. Business people rely upon insurance companies and attorneys to do those things.
Why is that reasonable?
Pardon?
Why is that reasonable? Well, are we just to assume that's reasonable?
Your Honor, it's not a reasonableness consideration. It's whether or not there was excusable neglect.
We know it's willful. That's what she did.
What she did was willful. Yeah, I understand what you're saying. The determination.
But why then, how do you overlay reasonableness over the willfulness?
I understand. I misunderstood your question. I understand what you're saying. If I understand correctly, you're saying it was a willful decision for her to turn this over to her insurance company and rely upon them. How do you make a determination that that's reasonable? I think you look at the real world circumstances of a business person or a corporation. That's just how they operate. She's a CFO.
How do we know that?
The affidavit states that she's the chief financial officer.
Yes, but I'm talking about how do we know that her actions are reasonable? She says what she did.
Your Honor, I do believe that's up to the court to decide whether or not it was reasonable.
And didn't the court do that?
No, Your Honor. The court said that it was willful neglect. The court said she did nothing. The court didn't consider the fact that she did take action. She didn't say it was reasonable for her to do that. The court said she did nothing. Several times the court said she did.
What do you think about the action she took after she received notice that there was going to be a hearing to determine the amount of the judgment? I know earlier she turned it over to the insurance company, but then you get this notice saying, okay, here's a hearing date for the writ. What action, if any, did the CFO take then?
Your Honor, we simply don't have that in the record. My hands were tied a little bit when we were setting up this record in that the CNO was out on medical leave and under prescription medication, was unable to give us information, so we were a bit hurried in what we filed, and I wasn't able to fully develop the record, so I can't really address that particular fact.
So it's very likely that she didn't do anything. She relied on the notice she gave the insurance company back in April, even though she gets notice of another hearing.
Your Honor, I think that's probably a reasonable assumption that may have been the case, but we don't know that. It's just simply not in the record, and I do not know.
Okay.
Now, in the alternative, in addition to applying an incorrect legal standard and reaching a conclusion based upon an incorrect analysis of the facts in this case, in the alternative, should the court find that the default judgment should not be set aside?
I think, and I want to go back to just what you were talking about, because I wanted to make sure it's right. What I'm reading in the court's order is Vicki Smith's discovery, the cause of action on April 15, 2024, and failing to take the necessary steps to protect defendant's interests, such as filing an answer or appearing at either hearing noticed by plaintiff's counsel, amounts to willful and deliberate neglect by defendant and is not excusable neglect under Rule 60.021. So she didn't say she didn't do anything. She said, at least in the order, she said she didn't take the necessary steps.
Your Honor, in the order, she also said on the prior page, 96, no efforts were made to protect defendant's interests prior to the writ of inquiry on May 8th, 2024.
Where does it say that?
Your Honor, I'm sorry. On page 96 of the record, it would be the First full paragraph, additionally, despite receiving notice, no efforts were made to protect defendant's interest prior to the writ of inquiry on May 8, 2024.
Okay.
Nothing was filed by the defendant. No representative of the defendant contacted plaintiff's counsel. No representative for defendant appeared to the writ of inquiry. All of that, as far as there was no one there, there was no response filed. All of that is true. There's no refuting that. Our position is she had taken the action she thought would be necessary for all of that to be taken care of. It was just simply a matter of,
She doesn't say that, though, in her affidavit.
I guess that's,
I may be misremembering what the affidavit says, but I don't remember the affidavit ever saying that.
Your Honor, it may not specifically say that. It does say that immediately upon finding this complaint, she notified her insurance company.
I believe that is correct, yes.
Yes, sir. And just ordinary business practice, that would be a reasonable thing for someone to do, and to rely upon their insurance company to then hire me, which they did, just not in time to do all the things the court said that Collierville 385 should have done.
Did I hear you correctly that you were hired on the same day that you filed the petition to set it aside?
Yes, Your Honor.
So we have the CFO discovering on April 15th, there's going to be a hearing on the motion for default judgment on the 19th. Between that time, she contacts the insurance company. But then after the 19th, she doesn't check to see what happened on the 19th. Then she gets a notice saying, well, the notice is in the default judgment, saying the hearing on the writ of inquiry is going to be on the 8th. And she does nothing to find out whether or not the insurance company is going to be present to defend the company on the 8th at the writ of inquiry. Why is any of that reasonable?
Your Honor, actually, nothing that happened after the judgment was entered, according to court's determination, weighs into whether or not there was willfulness or not. It's what was done prior to the judgment being entered. So that's one of the reasons why those facts are not really fully developed in the record, because we didn't find them relevant.
Okay.
Thank you, sir.
Thank you,
You still got your minute left.
Oh, thank you.
Good morning to the court.
Morning.
My name is Lisa Stanley. I represent First South Financial Credit Union. Of course, I think we've narrowed everything down to the relevant time periods that we've got. I'd like to address a few things regarding the appellant's brief. I'm not sure whether they matter in the long run, but I do, and they argue that it's not important, but I feel it's important to point out as well. The court decided to give the benefit of the doubt, Judge Wagner did, that they didn't have a registered agent for 6 months when we filed this lawsuit. When they filed their first motion to amend, to set aside the judgment, they advised us that the registered agent, who was listed with the Secretary of State until June 11th of 2024, had not been with the company since September of 2023. When we talk about negligence, when we talk about the willfulness of this was a self-driving car with no programming. Nobody was concerned about what was happening in this business. As far as the record, though, as well, we have Ms. Smith, the CFO's affidavit, that Penny Stein told no one about this, but we have no affidavit from anyone else at the dealership, not the general manager, not the CEO, no one. We have no affidavit from Penny Stein, which was an important point in the recent case that Your Honors decided in Brown versus HDR, that there was no affidavit there from the registered agent, that she never gave notice to the company. So I think that's important to point out. But in the meantime, Your Honors pointed in on exactly what we're talking about. Ms. Smith, at a very minimum, had notice 4 days before the motion for default hearing. I had notes to discuss. She contacts her insurance company. We all know insurance doesn't cover every claim. They have to review it. They have to decide if they're going to cover it and retain counsel for their insured. She calls, I suppose, I'm saying she calls, she contacts them. We have nothing in the record about how she contacts them. What she tells them she's received, there's nothing in the record about what she discovered. Was it only the complaint? Was it the motion for default that had been sent out at that point in time? So as Your Honors pointed out, she knew there was a hearing on April the 19th. There's nothing in the record that she followed up, made any inquiry. Are you covering us on this motion? Is this getting handled? This is a big corporation. I mean, I say big in a new car dealership, but they can hire counsel to appear, to contact myself when this is pending and ask for a bit more time to file a default. It happens every day in Shelby County, all the time. I get a call or I make the call. If I'm retained closing in on a date, the first thing I do is pick up that phone and call plaintiff's counsel and see if I've got enough time to get by, or if we can agree to time, or if I need to get to work overnight. And this is the first time in the appellant's brief that we've been told that they were retained and filed their extensive first motion to set aside judgment on the first day. You know, we don't know exactly what Ms. Smith, the CFO, discussed with her insurance company. Appellant makes a big argument about Williams versus Baptist, which was an excusable neglect case that was on a denial of a motion for extension of time. We're not talking about a motion for default. We're into the case at that point. Your Honors, the circuit court simply did use the correct legal standard here. From Discover versus Morgan, there's a test. Is the action of the defendant willful? If it is, then that's where the inquiry stops. If they find it excusable neglect, then they have two more hurdles to cover, which is a meritorious defense and whether or not there's prejudice to the other party. Judge Wagner made clear here that she had studied on this. She found it willful. She could find it nothing but willful. Their failure to have anyone contact me, contact the court, file an answer, just appear at the hearings, period.
Let's talk about that a minute.
Absolutely.
So she made the finding this is willful. And all the evidence in this record comes from either the pleadings or your affidavit, as well as the affidavit of Ms. Smith. Are there any other affidavits?
No, sir.
So the court reviewed those two affidavits, reviewed the pleadings, and made the determination of willfulness.
Yes, Your Honor.
How do we review that, since we don't have live testimony where there was no credibility finding, but we simply, and I'm assuming the finding of fact or willfulness is a finding of fact.
Yes, Your Honor. Well, again, in the recent case with Brown versus HDR, this is a deferential abuse of discretion case, right? So it's a lower standard of review. Awareness of the court's decision involved a choice among different alternatives, finding excusable neglect.
I understand the abuse of discretion standard. I'm asking from, do we make a de novo finding because all the evidence is documentary? Is really where I'm trying to go.
Yes, Your Honor.
Is it like us reading a deposition and the trial court read the deposition, we read, and the trial court finds one thing? Are we to reread the deposition and make our own finding?
I don't believe so, Your Honor. I think that the circuit court had the evidence before it. It made the legal decision.
Same evidence we have.
Of
and there's no
willfulness.
credibility finding made.
Correct. Your Honor, I think that it needs to give deference to the circuit court's decision that this was willful conduct. The burden of proof was on the appellant to prove that it was excusable neglect.
And that's where I'm going with this, the deference. Yes, this is an abuse of discretion standard, but the finding made by the trial court was made not by hearing live testimony, not by making credibility determinations. It was made on just a cold record.
Correct, Your Honor.
Can we make the same finding?
I think you can, Your Honor, yes.
So what about the deference to the trial court then?
Well, I think, well, if Your Honor is looking to whether or not they, the trial court made an erroneous assessment, I think you do have to look at the documents on that. But I think that everything supports her assessment, that this was willful activity.
Well, that seems to be the argument of the appellant, is the trial court made an erroneous assessment of willfulness.
Yes, Your Honor.
I'm just trying to figure out how you suggest we analyze this.
Well, Your Honor, I just think that you don't go back and rejudge, I'm sorry, and go behind the court's determination of her findings of fact.
Why? Because we can make the same findings of fact on a cold record without any credibility determinations.
Well, she of course had no credibility determination other than me standing in front of her, being one of the affiants, Your Honor. But of course, our certificates of service, as far as what was sent out.
Well, I don't think there's any question about what the facts are. It's just whether the facts amount to willfulness.
Yes, Your Honor. I think that not only the facts that are before the court, but the facts that are not before the court.
I'm not sure what that means.
I'm sorry. Well, what's not in the record that Mr. Sadler referred to, that we don't have anything in the record regarding her contacting the insurance company, et cetera. But ultimately, Your Honor, I mean, I do think that you are allowed to look back at the two affidavits. I mean, that's really all that is there, and make your determination.
Okay.
Your Honor, the appellant's argument also discusses footnote 4 of their brief. They claim that Ms. Smith, the CFO, can't appear before the court, or that would be unauthorized practice of law. Again, I go back to, they could have retained counsel for the limited purpose of getting an extension until insurance was covered. They also have no affidavit from the insurance company about the timing or how they did anything. And I'd also like to point out that even upon contacting the insurance company on April 15th, it still took more than 30 days for them to hire, retain counsel, and get anything filed. And Your Honor, as far as the fraud issues, they've brought up then the sufficiency of the pleading of fraud in the complaint. That was not brought up in either of their motions. And the only thing referred to at oral argument was, if Your Honor sets aside this default judgment, then we might argue the specificity of pleadings of fraud. Not that we will, not that we have an issue. Also, arguing that the whole purpose of the specificity pleadings is to put the defendant on notice. They're obviously on notice. They say we have a meritorious defense. So I'm not sure how they wouldn't be on notice. Also, if you just go through the complaint, Your Honors, I believe that we have met the burden of specificity of pleadings as to fraud in each of our allegations. If Your Honors have anything else, I'll yield my time.
I see none.
All right, thank you.
Thank you.
Your Honor, I anticipated this throughout this entire process. First South has argued something about service. There's no dispute about service. This is not about the service. They've argued the sloppiness. It's not about sloppiness. It's not a car wreck. It's not a negligence case. It's about willfulness. And the record shows a lack of willfulness on the part of Collierville 385. And the courts have consistently said liberality should be used in making determinations of whether or not to set aside a default judgment, that if there's any reasonable doubt, the determination should be made on the merits. Thank you, Your Honor.
Thank you. Thank you, counsel. We will take this matter under advisement and endeavor to get you an opinion at the earliest possible time. We appreciate your argument, and you may be excused. Thank you. Ms. Ann?